always refer you to somebody who's smart and capable if you do monitor training. That's a good question. Are there any other questions? I'm just about done, so I can leave after these guys.
Can a parent say to the school ahead of time, at the beginning of the year, we sign off on all those papers, we send something, an email, whatever, that says, you do not have the right principal, teacher, resource officer to speak with my child without my permission.
You can, but it's meaningless. It's meaningless for a couple reasons. One is, everyone's going to forget. Two is, who's going to see it? And third is, it has no legal significance. So you can do it, and there's no harm in doing it, because somebody might remember the assistant principal in Yorktown is fantastic, and he really cares about kids and not getting kids in the criminal justice system. And if he sees it, he remembers, he might say, you know what, we're going to call the parents first, the school resource officer, because I remember her concern about this issue. So is there harm? No. It has no significance, real significance.
It might have a significance for school violation of school rules, though, because it's used against students in discipline. It's used against students in disciplinary hearings for school violations. So although it may have no legal significance for criminal cases, it could be a factor.
So, I had a lot more anecdotes, a lot longer story about the point is. The point is, do not answer police questions and do not consent to searches. Do you got that? Is there anybody who thinks, yeah, but sometimes anybody? Yeah, but
search of bags, cell phones.
Nothing. Well, and you guys know this,
bags.
right? If you guys don't know this, James and Juliet, I don't know if you've been around long enough, but James and I have. There used to be a time where my cases were all about bags and cars and purses, and now they're all about phones, what's on your phone. Guys, put a password on your phone and don't give it to anybody. Nobody. You never give your password. What's that?
Except your parents.
Your parents, that's right. That's right. Slight technicality for the parents. I have not seen it done, and these two weigh in. When your kid comes home after this, and then you say what happened, and they tell you, well, what happened was, and there's all sorts of crimes happening in the middle and high schools. There's sex crimes, there's pictures, you know what I'm talking about, pictures that can be taken on your phone. Yeah, they do. And there's drugs. Those three things are really common, and alcohol in the school. You tell your parents, technically parents, you can be subpoenaed as a witness and forced to testify about what your child told you in a criminal case. I've never seen it done. Never. I've prosecutors, I don't know why. No.
I had a client, I had parents subpoenaed just 2 years ago here in Arlington by Theo Stamos.
So you want to be a little bit cautious, parents, about interrogating your child under the, I'll tell you about what's right. Now, if it's a minor, if you think it's pretty minor, fine. But a lot of things you think are minor aren't, especially the wildly disparate, disproportionate, crazy prosecutors about pictures on the phone. You guys all know, I think, that if a child takes a picture of their butt crack and emails it to their friend, that child has produced Never have pictures on your phone. Never give your password to your parents. Parents, you know that you can't lie to the police, but you don't have to talk to them. And when you get that phone from that, you plug it in before, and if there is a criminal proceeding and they ask for that phone, that's obstruction of justice. But before that, when your child comes home, plug that phone in and you erase the hard drive. You get rid of everything. You don't just delete the picture, you erase the entire phone. If somebody looked for it, right? If you find it, fine, delete the picture. But the pictures on the phone, it is causing us, it is keeping lots of law offices employed. Kids keeping
It's
pictures
sending your
on
kids to college.
It sure is. If you just take a few more pictures and send them around. And how are you being caught, right? This is the thing that kids are always like, well, nobody's looking at my phone. When you send your text, your mean text, your nasty picture, When you send something to somebody else, you've completely lost control of it, right? You don't know that your friend's parents haven't taken your phone and looked through it. You don't know that your friend hasn't sent it on to 10 more kids, and 10 more parents are looking, and it gets back to you. My own son was arrested, and that's how he was arrested. A parent found the phone, looked at the phone, and called the police. And, you know, it happens. That's how you're gonna get caught. Not from your own sloppiness, but from you sharing it with other people. So you just don't do that with
So,
phones.
quick question, John. So if the parent gets the phone and there is a bad picture on there, and there's no investigation yet or anything, and the parent deletes the hard drive on the phone, but the child has already sent it out or whatever, what's the evidentiary, weight of that?
That's pretty heavy.
It's already,
The
it's
kid's
already
gonna say,
gone. So it doesn't matter that.
hey, when the kid gets it, and the police come to the kid that has it, right? The police gonna go, where'd you get that from? Well, I got it from Jimmy. The kid's gonna be nervous because he can come here and he can learn not to speak to the police. And then your child is gonna have a really hard time when his number is on that phone saying that's not my phone. Now the police, if we get involved early enough, the police can have a hard time linking your child's phone to your child.
Right.
Okay, so I'm gonna give you another example that's very, very apropos here. It's a house, and this happens, there's a house with 3 teens, and there's pictures being downloaded to the computer that should not be. And the police know about it because they're monitoring the internet. They don't know it for any other reason. They get a search warrant for that house because the IP address comes to that house. They come to that house, and I'm gonna guarantee you, if everybody shuts up, there's nobody in that house is guilty of anything, because there's no way to prove who in that house downloaded those pictures. And let me give you, I'm gonna go back to that in a second. It's the same thing as a car. A car gets pulled over, and there's pot in the console, and there's 4 people in the car. Everybody get out of the car. Whose pot is it? And the pressure's on. Come on, if you just tell us whose pot it is, we'll let you go. No. Nobody will ever be convicted for that pot if you all just shut up, okay? Just be quiet. Possession has to be linked to you for a conviction. So in my case, my parent did what he thought was smart. Here's the police. He's got 3 teens. He says, police, let me assure you, nobody uses these computers without my permission. I know the password, and I don't give the password out to anybody. Guess who was convicted? He was. 12 years.
Are you scared?
12 years. 12 years for pictures that weren't on the computer. They never found anything on the computer. The police just got them as they were being downloaded through the IP address. All the computers were clean, but they got possession because the guy claimed nobody in the house used the computers but me. So just be quiet. You just can't say anything. You think you're helping, you're just not helping. You gotta say nothing.
I have one question.
Yes.
If the picture is floating around the school or whatever,
Mhm.
what's the liability, I guess, the risk to the kid who gets the picture?
Same thing. Let me give you an anecdote, and then you'll know exactly what the risk is. True story, Loudoun County High School. An assistant principal is told that there is a picture going around, and this one particular student, Jim Smith, has it. And what the assistant principal thinks is that broke a picture with her shirt up, of her boobs, and sent it to her boyfriend. And everybody's talking about it at school. So the assistant principal takes the phone from Jim Smith. You're worried about Jim Smith, right? What's his liability for receiving it? Guess who got prosecuted for possession of child pornography? The assistant principal. For taking the phone. The prosecutor, Jim Plowman, who is now the judge, knew that Jim Plowman did not think that assistant principal was looking at pornography. He did not think that he had anything to do with it, but he was literally in possession of the phone with a picture on it, and $120,000 later, the charges were dropped. $120,000 later, the assistant principal went free. So you are liable. Possession of pornography means somebody sends you a picture, it's on your phone, you're in possession of it. There can be times when possession is hard, and the other part of it is, you guys, you're all backing up your stuff to the cloud. Everybody keeps the stuff backed up, great. That means everybody in your house now possesses it, right? Because it's on the cloud, everybody's got backups, who knows? All the backups, you know that when you back up to the cloud, most of these servers have algorithms to look for child pornography and report it to national law enforcement. They send out warrants. So if you have, and I have had 2 cases so far in the last year, a client who had a picture on his phone, got uploaded to the cloud, went to his Flickr account. Flickr has an algorithm owned by Google that alerts the National Center for the Exploitation of Children. They got a search warrant, and now everybody in the house is charged with possession of pornography. So be careful. So basically, are you going to consent to searches? Are you going to give the police your phone password? Can I just ask you a few questions? No. Okay, good. You got it. That's it. Miranda warnings, because everybody asks. There's no Miranda rights. Okay. You can find the word Miranda rights all over the internet. There's no Miranda rights. There are Miranda warnings, and if you get them, good, and if you don't, it doesn't matter. So it only matters when I go to court and we're trying to suppress your statements, but you have no right to get Miranda warnings. Does anybody have any questions? Any questions about Miranda or anything else?
Could you explain to them what Miranda is?
Oh, have you guys heard about Miranda? You guys all have? Maybe most people have, right? You have a Fifth Amendment right against incriminating yourself. Miranda is a 1960s U.S. Supreme Court case that said, well, nobody knows that, so we're going to require the police to give warnings if they want to use statements from you in court, and it's only when you're in custody. So you'll never get warnings until you're arrested, and you'll never get warnings unless you're being questioned, and the warnings mean nothing unless you try and submit your statements to a court, to a
I
jury.
really thought it was required. How did I miss that in middle school?
Required if you're arrested.
It's what we call prophylactic, right? It is just preventing custodial interrogation statements from being admitted against you. That's it. So, when 2 police officers are driving you to the police station, true case, and it's a murder case, and they don't know who did it, and they're saying, gosh, guy in the back seat is arrested, right? He's in custody, he's in the police car, right? And one cop says to the other, geez, it'd be nice if the family really knew where their daughter was, their dead daughter, even though she's dead. It'd be nice if they knew where the body was before Christmas, wouldn't it? The other cop says, sure would. And the defendant says, well, she's buried over there in the woods. Can that statement be suppressed? He's in custody. It's a statement, but it wasn't in response to the question. So, no, that statement came in, he's guilty of murder. So, Miranda has limited use, and you have no rights to get them. It's just that they don't give them to you. If they don't give you your warnings, it's going to be hard to use your in custody statements. I know it took up a lot of time.
Just a quick comment.
Yeah.
Mr. Sheldon was really hammering home the point of why you should not talk to police. Young people, you should definitely tell your parents the truth. Whatever the truth is, you definitely need to tell your parents the truth, because your parents need to make a wise decision as to whether or not to hire an attorney, number 1. And number 2, by all means, tell your attorney what happened, even if you didn't reveal the entire truth to your parents, because your attorney does not want to be blindsided and cannot represent you in the best manner possible and get the best possible outcome for you if he doesn't know the truth of every single thing that happened. So please do that.
And I'll follow up briefly on that, because one of the points I wanted to make tonight is that there is no privilege between parents and children. So you may have heard of attorney-client privilege, which means that your communications when you're getting legal advice are protected by the law. There's also doctor-patient privilege. You may have heard of that, which means that the doctor can't reveal your private, medical information to other people, except under very narrow circumstances. But
And then we
children,
have the priest penitent.
right, priest penitent, and
And
there's
spousal too.
and spousal.
Husband and wife. You
Right.
can tell your spouse, because Virginia has a policy not splitting, couples apart, not forcing
Right.
them to testify.
Right, there are some limitations, but there is no parent-child privilege. So what that means is, although I appreciate what you're saying about the need to get an attorney, the fact is that you could be called as a witness, and I was very shocked when that happened to one of my clients here in Arlington. I thought it was extremely heavy-handed to be calling a parent to testify against the child, because that is really so you could have a family member called to testify against you. So, you know, parents might not want to do their own investigation, they might want to leave that to the attorney, you know? You know, if it's serious enough, it looks like it could be criminal, it's gonna be treated as criminal, prioritize getting an attorney in place for your child. That's what I would say about that.
Good to know.
Yeah, and I would echo also that the attorney needs to know what the exposure is, you know, how exposed are you to this criminal offense or this criminal charge, based on your behavior, and it is not unusual for children not to tell the truth to their parents if they're saying something wrong and they don't want to admit to it. That happens, but you have to tell your attorney, because otherwise they don't know what kind of case they're dealing with or what the exposures could be. And sometimes charges are amended. You know, they start off with a lesser offense, and as the police continue to investigate, or if admissions are made by kids or by the parents can make admissions too. Okay, that's something that's really important to point out. That can actually end up increasing the charges, the seriousness of the charges that are brought. And so, you know, one of the things I think that a lot of parents do, and they may make the same mistake that the kids make, which is they'll go in and they'll talk to an administrator, and they may interrogate their child in front of the administrator. Okay? Meaning, by interrogate, I mean, ask them a bunch of questions in front of the administrator, and then all of those notes are taken. Any kind of conversation, it's very, very common to be asked, you know, well, what did they tell you about this? What did your child tell you about this? And then you start talking about what they told you, well, then they're taking their notes. All of those are statements against interest. They may fall outside of any kind of evidentiary rule, and they could very well come into court. And so, those are real exposures. Those conversations that you have with your child are real exposures, and could potentially result in maybe your statements and their statements to you being used against them.
So have those conversations out of the presence of administrators.
Yes, and preferably with an
With your
attorney.
attorney,
Okay, and keep in mind, the juvenile defense attorney is actually going to be speaking separately with your child. So, you know, that's their duty to do that. If you're not the client, they shouldn't be having a joint conference with you either. They should have a separate conference with you so they can figure out what you know. That's really important, and figure out whether or not there's any daylight between what they learned from your child as opposed to what you know about what's happening to the child. And they have their privileges which attach to the child. And so there again, if you're not the client, there may not be a privilege there.
And one thing, I asked a few teenagers about this before I came in. James, maybe you could address this. They asked, the question was, why? You know not to talk, yes. You know not to consent to a search of your phone or your back, yes. Well, why do you say yes? And they say, well, I don't know how the police officer will respond. What's your experience? How will the police officer respond when a teenager says, I'd like to call my parent, I don't consent?
Well, if a teenager says, I'd like to call my parent, typically, officers don't respond hostily, they just allow them to call their parents. Now, obviously, there are going to be some exceptions, but typically, the professional police officer will allow the kid to call their parents.
And if the kid says, I don't want to ask any questions, either I'd like a lawyer first, I'd like my parent, you know, do you think they put themselves at risk with a police officer in an average situation?
In the typical situation, no.
That's my experience too. In Arlington, the police are very respectful of people that just invoke their rights. Can you? Yes. Should you? Yes. You have a basic fundamental right to do it. You should do it. And I think James's point is right. And the police will respect it.
And they may still continue to carry on and carry out a search, but that there is a possibility that they would have some legal protections from that search.
Exactly.
And that's the salient point. If you allow that search to happen by consenting to it, you are waiving all of your constitutional rights with respect to that search. Period. It's gone.
That's a great point. It doesn't mean the search won't happen.
Yeah,
It
right.
just means
Right.
that they got a lot more hurdles to get over to get
That's
that
right.
evidence in court against you.
That's right. And I wanted to talk a little bit about, you know, the overall you're as guilty of the worst thing someone with you ever did, right? So, I mean, and that, you're talking about felony murder in the case of a murder case, but it doesn't have to be a murder case.
Yeah.
It could be something
Vandalism.
little. Vandalism, a situation at the community center, one kid who's a friend starts burning paper in the bathroom, and there's this other kid with them. You've got a problem if you're there in that setting. Your child has a problem. They need to not be there, right?
Yeah.
I mean, first of all, they leave immediately, but that is a dangerous mission. If you've got, you know, your child is hanging out with kids who are doing dangerous things and they're getting themselves in trouble and they're placing other people at risk, I would get on the horn. I would talk to my child and say, you can't spend time with children who are doing that. You just can't be doing that. Or if that child's placing other children at risk, and I've specifically seen where, you know, there's going to be, we have to consider some of this implicit bias issue around parenting as well. And I counseled my own child who had a child, a good friend of his who's a child of color, was spending a lot of time with a white child who was doing some of these dangerous things. And I told him, I said, you've got to talk to that kid and tell him that this is not safe for him. He cannot be spending time with his child. I'm sorry, but he's not doing that. By the way, you're not allowed to spend time with this child. And if you don't communicate that, I'm going to get on the phone and call his mother myself, you know, because it's just too much exposure. And you don't know where things are going to go. Something that seems like someone playing with matches will turn out to burn the community center down and people get killed.
We have the
You don't know
simplest
where it's
little
going.
burning cases. I've had 2 burning cases. 4 kids playing around. It's all fun, right? You're not doing it, but your friends are. You're all laughing, and it's a little porta potty, and he burns the toilet paper roll, and it significantly burns the porta potty. But guess what? All 4 kids are charged with the worst arson, burning of a dwelling. They called a porta potty a dwelling. Yes, and that's what they charged them to get leverage, right? Charge them with the toughest thing you can. And was it damaged? Yeah, it was significantly damaged, but could still be used. But they acted as though it had been destroyed. The entire thing needs to be replaced. Just the toilet paper. But and you think it's funny, right? Your friends did it, and you were laughing. But every single child, all 4
That's right.
boys, charged with burning of a dwelling.
Now, the other piece of it is there's this memorandum of understanding that's between Arlington Public Schools and the police department. And it lays out some of the limitations and expectations of how the police are expected to behave when they're investigating potential criminal offenses within the schools, okay? And there are some good things in there. I think there's some positive statements about, you know, taking into consideration the developmental age of students and, you know, disability and so on. But guess what? A lot of this is a policy. It's not going to protect you legally, okay? And the fact is that even though they say in this memorandum of understanding that the police are never agents of the school district, and they're never to be treated as agents, and vice versa, the administrators are not supposed to be treated as agents of the police, they are operating hand in hand, hand in glove together all the time. Why do why are they the primary people carrying out investigations in schools? Well, on the one hand, yes, it's about violation of school rules. On the other hand, none of those criminal investigatory protections apply when, or virtually none of them. Certainly the Fifth Amendment, right against self-incrimination piece, does not apply, okay? Meaning they have fewer obligations than police officers. So they're not going to give your child Miranda warnings. They're not going to tell your child, this is a criminal investigation, you might get charged with a fine. They're just not going to do that. And so you have to go in understanding that they're going to investigate, and all of the information that they uncover is going to be used for criminal investigation purposes if there's a potential for a criminal charge. And this would be very basic, very unexpected behavior. I actually had one case here in Arlington that involved a student who was disrupting the classroom, interrupting the classroom, disabled child, charged with a misdemeanor for disorderly conduct. And quite honestly, this was disability related, and in fact, one one of the protections that does exist under special education law is that they have to do a manifestation determination, which is a fancy term for figuring out if it's related to the disability or if they failed to implement plans that they needed to implement to provide services and accommodations to that student. And if they failed to do that, and if it was disability related, then they're not supposed to punish the child, okay? But it's complicated, and that doesn't mean that that's binding on the police, number one, okay? So, and it doesn't mean that the police have to take that into consideration, because diminished capacity, disability, as a general matter under most of the law of this country, certainly in Virginia, is not a defense to criminal charge. And so we are dealing with a situation where if we lack a common sense approach to how we are defining criminality in this country, we're going to criminalize childhood altogether. I mean, that, extreme cases, come up on the internet all the time. I don't know if you've seen some of the things floating around in social media, but there was a child who had a tantrum like a toddler, 6 years old, and was charged.
Can you talk a little bit, Julia, just about the Virginia disorderly conduct statute and how broad that is,
Yeah.
and loose as
Yes.
far as elements?
So part of what we're seeing in Virginia law in general is a departure from what were some of the old rules of common law. So these are rules, coded rules that we've had, the legislature passes, are now allowing for things to become criminal that would not have been criminal under the common law. Common law being sort of case-based law that came from England and that was adopted here in the United States. And so there was this very strong focus on intent for criminal charges for the common law. That's often being stripped out and is often not required in order to find someone guilty of a crime in Virginia. And in this particular case with the disorderly conduct statute, there's a special provision under that statute that criminalizes disruption, just interruption. Anything that interferes with the operation of the teaching in a school can be criminalized. And so, we need to change that law here in Virginia. It's a very significant, serious exposure for students in particular. In theory, it doesn't only apply to students, but in practice, it's only being applied to students. And there have been a lot of people trying to make that happen for a long time. It's a catch-all. They don't want your child to be doing X, Y, and Z, or let's say a child is really disrupted because of their disability and you're tired of having to deal with this kid. Charging them with disorderly may be a way of getting them out of the school. And so, it can be really it can be used in an abusive way. I'm sure, have you seen that?
I'm not saying it, but I can suspect it happens.
Yeah. So that is a big concern. I'm trying to think if there's anything else major that I wanted to cover. I don't think that the memorandum of understanding is all that helpful, except as sort of providing guidance to the police on what administrators expect of them. But no one should be in any doubt that administrators are conducting basically police investigation with the guidance of the police. I mean, that's what's happening. That is what's happening. And so, you may have some rules that are a lot easier, for example, for administrators to implement, like, you might remember the announcement about the drug sniffing dogs that went into the high schools. And there are cases on the books related to the rights of students and searches, and students have a much lower level of rights in school than they have elsewhere. And the reasoning is that the schools are something called in loco parentis, meaning that they're standing in as parents, as if they were the parents of the children. And therefore, they can consent on behalf of the children to allow searches. So it gets really tricky if you've got the dogs coming in and they're escorted by the administrator, and the police have the dogs, but the administrator is the one a legal question then, whether or not that search was actually a police search or if it was an administrator search. So it's difficult. Oh, one other thing.
But
yes.
but the parent and student role is easy. Don't
Yes.
consent to the searches.
Correct.
Don't answer questions.
That's right.
It doesn't change anything.
That's
This is
right.
very easy.
They're
What you
still
need to
they
do.
may still search, but say
Who
no.
cares? They could search
Say no.
illegal searches, they can make legal searches, you're not gonna know at the time whether
Right.
their search is legal, illegal, and it's not of
That's
your
right.
concern. Your concern
That's right.
is to be respectful, to understand the police really do help us, they're there to do their job, and you're gonna not assist them in that moment by answering questions.
So Arlington schools, loan these, electronic devices, laptops, MacBook, all of that, is their property. If they say, give me
Yes,
the computer that
they're gonna
is
approach
our
a child
property.
in school and say, can I, give us that computer, and they're gonna search it. So students, you should never have anything on any of your devices, but recognize that your school iPad, and your school, laptop is much less secure, and if you received anything, which is unlikely, on that, it's gonna be searched, and you're gonna have less protections for that,
And can
much
I
less.
just add a piece to the iPad students? If you have a personal iPhone that your parents gave you, do not, under any circumstances, use your Apple ID and put it into the school's laptop. Do not, I mean, the school's iPad, sorry. Do not put your personal Apple ID or your personal cell phone into the school's iPad.
Oh, I see, because
Yeah.
your email and everything. you have the
Everything
computer
can get
remember it for you.
populated, exactly, because Apple does that, it likes to,
no,
it's
it's
designed to
fine.
pull things, everything together. So then, suddenly what's on your phone at home, you just never know, could populate on the school's iPad. And you can't say no to them taking that iPad.
So if it's a school piece of tech, they have the right at any point to say, we want it back. Okay.
You can't withhold consent
From someone that
on
doesn't.
property. Right.
Yeah, it's
So keep your personal
You
passwords.
can withhold
all that.
consent, right? You
Well,
just have to
can,
give
but
the
it just
computer,
won't.
but you won't
Yeah.
say, yes, you can search it, you would just
Right.
say, here's your computer, if they take it from you.
Exactly.
Right,
And they will search it.
right,
It's theirs.
right, you have to do that, it's not
You don't have to put all the passwords in.
One thing that some people have asked about is the fear outside of school of police abuse. And I've had a lot of cases of severe abuse by correctional officers, sheriff's deputies, and police, but every single one of my abuse cases is foreseeable to me. It's not a child respectfully saying, no, I'm not gonna answer your questions. I've never had that, 25 years, never had a friend who's had somebody get beat up for that. My high school students who have been badly beaten because of mental illness, because of severe alcohol and drug use, and not complying with, basic commands from the police to stop doing whatever they're doing. It happens. I don't think you should ever think, I'm not gonna respectfully decline a search because I might get beat. That's not realistic. You're gonna hurt yourself. Much worse by consenting and answering questions.
One other thing around, the impact of outside offenses, allegations of criminality outside of school, that actually can result in, school discipline. And it doesn't have to be on school property, although that's certainly the case. It doesn't have to be on a school bus or a school bus stop, although that's certainly the case. If you are walking to and from school and something happens, that could be subject to school discipline. And any time there is any kind of connection to any individual with anything that happens could potentially be used, a criminal matter could become part of the school discipline matter. So to give you an example, I worked on a matter once, where there was a serious charge for an assault and actually a robbery. Okay, so multiple felonies. Okay, and that involved students who were within the same school district, and the students were expelled from school as a result of that involvement in that situation. So just because it doesn't happen on school property aware of that. It can be really serious. Another thing is, if your child does have a disability, you should definitely see what you can do to get it documented, because there are some protections from school discipline that are associated with criminal cases. From being expelled, they may have a greater access to the ability to continue receiving their education if they've been properly identified and you have paperwork in place.
Any questions?
It's interesting what you just said, because I made a statement to someone that it's a shame, but it's not a shame, that an IEP gives you greater protection than not having one. So what I've said to certain people is, it's not shameful to have that IEP, you actually have more protection than what's called a regular student.
And you have more protection with an individualized education plan or an IEP than you have with a 504 plan. So it's important to be aware of those things. I mean, there are some exceptions, but it's pretty severe, pretty significant cases where you can be removed.
Can I ask a question about the IEP, Juliet, and possible defenses? My understanding and what I've heard is that there is a section on an IEP for a parent to add a statement. And if, for example, a parent has a child who has ADHD or oppositional defiant disorder, a lot of times those coexist. Could the parent then say, you know, in certain situations, a child's impulsivity will cause him or her to act violently, or will, you know, has a harsh reaction to being teased or whatever because of the impulse control issues and what have you. And if that's documented on the IEP, and then there is subsequently down the road a criminal charge or a disorderly conduct charge or what have you, could that be used as a defense as it was previously documented and accepted and signed off on?
So it's better if it's in the body of what the team agrees to, okay?
So that's not where the parent statement is?
The parent statement is just a parent statement.
It's not in the document?
Well, it's in the document.
Okay,
So, you know, that places that in question.
okay.
But just to back up for a minute, there is one very narrow provision of state law that I worked on that is on the books right now that relates to that kind of evidence. And it actually creates a potential defense for misdemeanor cases, so those minor cases. Disorderly conduct is an example of that. Simple assault is another example. There are a number of different examples. Possession of marijuana, right? Tobacco offenses, alcohol offenses. Those types of offenses, you could potentially raise the defense based on this kind of problem, saying, hey, this was disability related, so you should dismiss the case. And that's actually on the books now, but it's narrow. It's school-based offenses, it's misdemeanors only, and it's only if you've documented it, and it had to have been documented before the
Before
criminal
the
case.
course, right.
So, as a general practice, I recommend that if there are any behavioral issues that place a child at higher risk of disciplinary involvement, but there's no examples of it, then you would put that in the parental statement under your parent concerns. That you're concerned that as a result of their impulsivity or whatever that is, that places them at higher risk of law enforcement involvement is what I like to say. Okay, and I will also add school disciplinary measures, law enforcement involvement. And so I do like that, but if there's something that's actually happened that could have been criminalized, then it's really important to get that documented. And there is, you know, it's sort of a trade-off of how much do you want the whole team to know about what's going on with your kid, as opposed to, hey, this really could have been charged, you know? And you know what is a really common one now is verbal threats. Oh my goodness, do we have so many issues with verbal threats? Because it's criminal. You can't make verbal threats that you're gonna kill or cause bodily harm.
You can't make nonverbal threats like this either.
Well, that's a different question. That's a different question. But yes, using gestures, there's even been charges brought against children on occasion for bringing toy guns to school. I mean, it has been very out of control in recent years in Virginia.
And sometimes those threats really are with the intent to place people in a lot of fear, but sometimes those threats are off the cuff. You know, I can't believe you did that to me. If you do that again, I'm gonna kill you. You know, do they really mean to place you in fear that they're gonna kill you? Perhaps not. But those verbal threats are being charged. We had a case here in Arlington where someone went to Wakefield High School with a car. Had come from, I think, Falls Church, and showed up with, I don't know what they were. They were the toy guns. Do you remember this case? Airsoft. Showed up with an airsoft rifle, okay? Started filming themselves on social media with their airsoft rifle, charged with, I don't know if it ended up being a terrorist charge or not, but that criminal charge was actually issued and announced publicly by the Arlington County Police Department. So, and you know, I'm not saying this was a young person, I don't even think it was a minor, but the point I'm trying to make is something that might seem innocuous if someone's, say, playing and they think it's funny and they're going to a public park, but it happens to be a school, right, is not gonna be viewed in the same way by law enforcement as other people are gonna view it, especially not in this environment. And so, yes, if you have a disability-related piece to it, it's really important to document that. There have been some cases, you know, around sentencing and solitary confinement, like sentences, death penalty related to juveniles, some protections in the law, in cases that have come down from the Supreme Court. But there's a lot of distance between those severe situations and what we see happening with kids all the time in the schools. And the truth is that once you've got that record, and they may be running you know, police may run through, if they got a suspect, they may come up with a list of suspects based on who they have in their database, you know? So once you've got that record, and it's a searchable record, you know, that's on your record. It's not, people think the juvenile law is
Vote on Tuesday.
yeah, go to
When the Democrats win the House of Delegates on Tuesday, we're gonna have a lot of criminal justice reform. And expungements is gonna be a big one. We have a lot of bills, and we're gonna be able to expunge things we never could before, so vote on Tuesday.
But now with the making threats, teachers can press charges even if the school administration chooses not to.
That's absolutely right, and that's another exposure that people don't think about. You know, when there's a potential exposure of that kind, I always counsel people to recognize that the school, even if administrators are not inclined to pursue criminal charges, that does not prevent a staff member from going and you know, going to the police.
Or another parent.
Or another parent and bringing a charge.
Yeah.
Right, and so, you know, this really creates a major sense of unease if you don't know, that could be hanging out there. I mean, speaking of texting, you can have a situation with the sexting thing. You can have one of those situations hanging in your head for months, years, because suppose there's two phones on either end. You don't know if that parent is gonna freak out, if they discover this thing at any moment in time and call the school, and then all of a sudden they're telling you.
And that goes to the technical part of this, like you guys don't use, do you guys use texting, or do you use Snapchat, or what do you use to communicate with stuff? What do you use? iMessage. So, now that Snapchat has become more common with the older teens, Snapchat is encrypted and the messages go away. As a parent, you might not like it. As a criminal defense attorney, I love it. So many of my 30 and 40-year-old clients, it's because of it texting and emailing, and they don't know how to use WhatsApp and Snapchat and encrypted messaging. Encrypted messaging of Snapchat, where the pictures and text go away, is just a boon to lack of criminal charges. I've only had 2 cases in my entire last 10 years that involved Snapchat because somebody took a screenshot of it.
Right,
I would be
I
screenshot
think
this
twice
one.
about giving your child a smartphone now, as a
Well,
teacher.
That's,
I mean,
that ship
that's-
sails.
that's-
That
that's
ship
where they're
is
gonna- that's where they're gonna get this stuff
Sophia,
from,
do you hear
is
this?
smartphones.
Turn your phone in right now.
Listen, even the
But no,
flip
that's where
phones
they
have
get it from. I
internet
see
access.
stuff going on in classroom, I'm
Yes.
like, get that out of here.
Yeah.
And I'm like,
Yeah.
if they didn't have a smartphone, they just a flip phone.
Yes,
They wouldn't be receiving the
That's
stuff, and
right.
there's immature, I wouldn't say stupid, but
I know.
immature.
You're absolutely right.
That's right, they don't have,
They don't have the
the
capacity to
reasoning.
realize what they
Yeah.
are doing, and
Right.
that's where, as a
But what parents need to know
teacher-
is those messaging systems where the messages disappear and they're encrypted, it's really helpful to your child.
But we don't really know the full scope of what people can obtain. And so I think it's.
Well, I've had
Wow.
numerous Snapchat cases and the police
I'm
can't get them.
well,
They can't get them. They
That doesn't
subpoena,
mean the
they don't
FBI
get
can't
them.
get them.
They can't
So-
get them, and they won't get them for your case.
Yeah.
You know,
The really
if your
good
child
photos
kills
can
3
say-
or more people, they might end up
But if
trying.
But if that screenshot is too bad, they have to
Just
Trying
say.
to remember this. But yes, but it's so rare that it's screenshot. Anyway, thank you.
How
Is
does,
that it?
how does bullying, like, is bullying fall in, or are there issues with bullying, with, you know, that can almost become criminal too?
Yeah, verbal
Like, or-
threats, assaults, oh yeah, absolutely.
And what
And
about?
some of the online
Cyber-
harassment is also criminal.
Is also criminal,
Yeah.
and then the use of like racial slurs against children, does that fall under?
So there's a curse and abuse, I think, is the curse and abuse.
There's these Arlington statutes that very barely constitutional. So there is a curse statute goes along with the name and address statute. I don't know if the name, you know, in Arlington, you have to give your name and address to a police officer. I'm fine with that. Give me your name and address. I don't know that's constitutional, but it's an Arlington statute. Same with the cursing one. But, you know.
What was the curse you want to say? You cannot curse?
Yeah, you can't swear. You can't
Where?
swear in Arlington.
Can't swear.
So if a kid calls another kid a racial slur, that would be considered swearing?
You know, I think the less we criminalize this behavior, the better. There's very little school behavior
I will
that's way
say-
overly criminalized. And you all know, and I think Julia, we're 49th and 50th, we're first or second in criminalizing student behavior in the country.
And that's,
We've had enough.
that's.
Nobody criminalizes more than we do.
And that's with the data being extremely imperfect, okay?
Right.
Because I couldn't get those numbers, all right? I couldn't get those numbers when I asked. So I was told, oh, the referrals are coming from so many different places, we're not really sure exactly whether they came from school or didn't come from school, or the police, or the SROs, or how they submitted it, and I'm like, well, okay, thanks for nothing. But yeah, I mean, we are, with the numbers that we do have, the numbers that were submitted to the U.S. Department of Justice, we were determined to be number one years ago, and I don't know that they've done another analysis since then. But this has to do with the laws that are on the books, number one, and number two, zero tolerance policies in schools. We have some very specific rules in state law that mandate referral to law enforcement. And so that's something that people have been trying to get off the books for a long time. We have another provision of law that requires police officers to enforce quote-unquote school board rules. That one, we even had the police association saying, let's get rid of that thing, because they don't really, I don't think they want to be having to settle school discipline issues that are not criminal. And we were, you know, it was opposed and we couldn't get that through. So, you know, we have there's a lot of basic problems with the laws that are on the books in Virginia. Any other questions?
James, you have any last remarks or?
Okay, the presentation that I'm going to do has to do with how to interact safely with police. If you stop them as a pedestrian or if you stop while driving a car. So if you want to take a 2-minute stretch break, I'll get set up and we'll be ready to go.